Well, I guess.
No, Your Honor, may I respond to that? Ridiculous. That's ridiculous because it's verified. The petition's verified. It's nonsense.
Mr. Torvinen, if you go off on a rant again,
I apologize.
I will act accordingly. Please do not interrupt me or.
I'm sorry.
All right. Good morning, ladies and gentlemen. Welcome back. Let's go back on the record in PR 14-000, that's 3025, and in the companion guardianship case. It appears to me all parties are present. Mr. Hillygus is present with his attorney, Mr. Evenson. Mr. Torvinen is present with his client as well, and I show the appearance of Mr. Spitzer. Mr. Torvinen, just to put belt on suspenders, do you have any other questions of Mr. Hillygus?
I do not, Your Honor.
Thank you. Mr. Spitzer, any questions of Mr. Hillygus?
No, Your Honor, thank you.
Thank you. Mr. Evenson, do you have any questions as a result of the direct examination?
No.
Thank you. Mr. Torvinen, your next witness.
Robin Renwick.
Ms. Renwick, would you please raise your right hand and take the oath of a witness?
Do you solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Great. Ms. Renwick, state your full name for the record.
Robin Renee Renwick,
Where do you live?
Reno, Nevada.
Okay. And how did you serve in this case? What was your role?
I was co-guardian of Susan Hillygus.
As person?
Yes.
With whom?
With Fiduciary Services of Nevada.
Okay. Now, when did this tragedy start? What take us back? What started this?
It started in fall of 2013 when there was agreement between the family members, my parents,
Stop
and my
there.
brother.
Okay, who's the family members that agreed?
Sue Hillygus, Steve Hillygus, Roger Hillygus, and myself.
What was that agreement?
Your Honor, I'm sorry. She spoke really quickly there. I didn't catch all those names.
Okay, sorry about that.
It's all right. Go ahead again, please, Mr. Torvinen.
Okay. Who were the parties to this agreement?
The agreement was between the four family members, Roger Hillygus, my mom, Sue Hillygus, my dad, Gene Hillygus, and myself.
And what agreement was this?
The agreement was made that my
Your
mom.
Honor, I'm going to object to any testimony about the agreement that was made, as it was apparently not judicially executed and I'm not sure why it's being offered.
The objection is relevance, Mr. Torvinen.
Yeah, the relevance, this goes to bad faith and the conduct of Mr. Hillygus just prior to the litigation occurring, and it's the same conduct. And this stuff is not in the record, Your Honor.
It
But
is
it's
not,
relevant.
hang on. It is not in the record, to be sure. However, Judge Doherty's order invoking the jurisdiction of the court in both the guardianship and trust case, finding Mr. Hillygus a vexatious litigant in both cases, had a date certain for which actions of Mr. Hillygus would be considered related to the request for attorney's fees, cost reimbursement by the guardians and other professionals. And that date is 2017, which is after the date of the agreement you're asking her about. And so for that reason, I find it irrelevant.
I'll move on, Your Honor.
Thank you.
Ms. Renwick, you said that you were you guardian for your father?
Yes, I was.
Okay, when did your dad pass?
August of 2015.
Yeah, that was Gene Hillygus, correct?
Yes.
Were you ever paid any money to be guardian?
No.
Okay. Now, were you later appointed guardian of your, or co-guardian of your mother with, I think it was Casey Zusman at that point, right?
Yes.
Is there a particular reason you sought a co-guardianship?
The reason I sought a co-guardian, a professional co-guardian, was because of all the accusations that my brother made about me as far as murdering my father. So when it came time to become guardian of my mom, I felt that it was necessary to hire a co-guardian to help me, although I did all of the work as far as taking care of my mom, taking her to her appointments, taking her to her doctor, her medical, getting her supplies. I did all of that for my mom.
Were you ever paid as co-guardian for your mother?
No, I was not.
Was there a time that Susan Hillygus actually lived with you and you took care of her?
Yes, she lived with me for 6 months,
About when would that have been?
from January of 2016 until June of 2016.
Until she was placed in Stone Valley.
Correct.
Okay. Were you ever paid for the care that you gave for your mother during that 6-month period?
No, I have never been paid.
Okay. So, to your recollection, at the beginning of this matter, if you know how much or what was in this trust, the Hillygus Family Trust, what was in there?
At the time that this began,
Yeah, to your recollection.
there was a house, there was about $350,000 in investments, there was a newer Honda Accord, there was a newer GMC truck, there were several transportation trailers, there were guns, there was antique wagons, 2 of them in the front yard. There were that's what I'm.
There was a tractor, wasn't there?
Oh, there was a tractor, a Kubota tractor.
As you sit here today, any of that stuff missing when you had a chance to look at it, and what happened?
The Kubota tractor is missing. The 2 transport trailers were never found. The guns apparently were sold in a garage sale with no proof of that.
Do you have any knowledge of the, if you recall my asking Mr. Hillygus about this, the utility trailer and the transfer to him? Do you know about that?
Yes.
What do you know about that?
I was at the DMV and they gave me
I'm
information.
going to object, Your Honor, on the grounds of best evidence rule and hearsay.
Mr. Torvinen,
I withdraw the question.
thank you.
What do you do for a living?
I'm a real estate agent.
And how long have you done that?
15 years.
And are you familiar or do you know about the residence that Roger Hillygus owned in Mustang, Nevada, and that out in Mustang? Lockwood, yeah.
Yes, I'm familiar with his rental property that he owned in Lockwood.
Okay, and to your knowledge, what happened with that property?
To my knowledge, that property was in.
Of hearsay and best evidence rule.
Mr.
She's
Torvinen,
Your Honor, she's a real estate agent and she does this for a living, and she looked at the records. So I think it's reliable evidence that she can talk about to her personal knowledge by looking what happened to this property.
well, none of that foundation had been established. I sustain the objection. You can rephrase or establish the foundation.
Okay, all right. Did you look at any records regarding, well, let's back up. As part of real estate agent, do you look at the property records for a piece of property?
Yes,
How often do you do that?
daily.
Okay. And you're familiar with this piece of property in Lockwood that was owned by Mr. Hillygus, are you?
Yes,
And did you look at the property records with regard to that?
yes.
Okay, what did you look at?
I looked it up because
Well, what did you look? What you looked up? What did you look at? What documents did you look at?
I looked up a property profile to see, I go to the assessor site, I can pull up a property. And so I pulled it up on the MLS and the multiple listing service to see that it had been sold in,
Your Honor, I'm going to object and ask that that be struck on the grounds of hearsay.
I sustain. Your next question.
Okay. Did you look at, never mind, I'll move on. You heard what I indicated about the modifications to the schedule contained in the petition to surcharge.
yes,
You agree with those modifications?
I do.
And as we sit here in court today, is there any conflict left between you and my other client, Kelly Lund?
No,
Okay. And you seek the remedies requested in the petition to surcharge?
yes,
Okay. You agree that there's 163 some odd $1,000 that would be available for distribution after payment of Danielle Christensen and me?
yes,
Okay. And you'd like the court to enter that order?
yes.
Okay. No further questions, Your Honor.
Any questions as a result of those questions, Mr. Spitzer?
No, Your Honor, thank you.
Mr. Evenson, I'm sorry, any cross-examination?
Yes. Thank you, Your Honor. Ms. Renwick, I just want to understand the last series of questions that you answered and where you're coming from relative to that. Are you saying that Mr. Torvinen's fees are solely designed? Well, let me ask you this question. Who does Mr. Torvinen represent in this matter, to your knowledge?
The trustee and the guardians,
And who are those people?
Kelly Lund, Fiduciary Services of Nevada, and myself.
Okay. Now, when he's do you understand the difference of him representing you as the guardian or the trustee and him representing you personally in this action?
I'm not sure.
Well, let me ask you this question. Why is it that all of the work being done, well, I'm sorry, Judge, let me rephrase that question. Have you reviewed the billing of Mr. Torvinen?
Yes,
Have you gone over it with him?
yes,
Okay. And do you have no issues with that billing?
no,
Okay. You have not filed an objection or anything like that with the court, have you?
no,
Okay. And relative to the monetary division that is to take place in this case, have you attempted to negotiate a lesser fee with Mr. Torvinen other than the now $81,000 fee we're subject to?
yes,
Okay. And was the result of those negotiations expressed by Mr. Torvinen on the record?
yes,
Okay. Now, can you indicate for me, and I'm not trying to put you onto the spot here, but can you indicate for me in Mr. Torvinen's billing records the difference between work he is doing for the estate and the difference in work he is doing for you as trustee or guardian?
it's this together.
Okay.
Your Honor, I object to that question. Working for the estate, the question was working for the estate and working for you as guardian. It's the same thing.
What is the legal basis of your objection, please? Hearing no legal basis, I overrule the objection.
Well, I guess the objection, Your Honor, is the form of the question.
I understand.
It's nonsensical.
I'm not asking for additional argument, Mr. Torvinen.
All right, I won't.
Let's move on. Mr. Evenson, please
Thank you, Your
proceed.
Thank you, Your Honor. So is it your intention today to have the division that is on page 10 of the petition be the order of the court?
I object to the extent that that question does not reflect the modification I made at the beginning.
Subject,
Understood.
I'll re-ask the question, Judge. I'll save the time.
Go ahead.
Subject to the modifications made at the beginning of the hearing, is it your desire to have page 10 be the order of this court today?
Yes.
Okay. Can you explain for me how it is that at the end of that accounting, Mr. Hilligus's share becomes yours?
Objection, Your Honor. That calls for my client to give a legal conclusion.
Same. Next question.
Okay, so are you aware that the remedy that is being sought by Mr. Torvinen is for you to get the entire 152,150, I'm sorry, 100, the number changed, whatever the number was at the beginning of the hearing, that entire balance is your sole and separate property. You do understand that's the relief he's requesting.
Yes.
Why do you believe you're entitled to that?
I believe that none of this would have even happened if it weren't for Roger's bad faith starting in 2013. I believe all the attorney fees should be charged to Rogers, going back to the $100,000 that he paid Woodburn and Wedge, and in bad faith never went through with that settlement or stipulation that we can't spend all the money coming to an agreement on. I believe we never would have had to hire Fiduciary Services of Nevada if it were for Roger's bad faith and bad behavior. I would
I
never.
believe you've answered the question. Thank you. Your next question, Mr. Evenson.
Thank you. Did you ever file an objection to Woodburn and Wedge's fees?
No.
Objection, that misstates the record. The fees were part of a stipulation that was negotiated with Margaret Crowley in a mediation. It's irrelevant.
I
You wouldn't
sustain
file-
the objection. Hang on. Don't say anything, Ms. Renwick. Your next question, please, Mr. Evenson.
Thank you. I will rephrase the question, Your Honor. Thank you. Weren't the fees that were paid to Woodburn and Wedge agreed upon by you as part of a judicial settlement?
As part of the stipulation.
Yes.
Your Honor, I object to the extent that's misleading because $20,000 of fees were never approved, but there was a lesser amount, 80, that was approved. So that misstates what happened. The
Do you
question
want to
is misleading.
Mr. Evenson, do you want to rephrase your question?
Yes, please. Whatever attorney's fees were paid by the trust or by the guardianship or by the estate of your parents to Woodburn and Wedge were in fact agreed to you as part of a mediation with Margaret Crowley. Is that right?
Same objection.
Not all of it.
Overruled. If you understand the question, you can answer, Ms. Renwick.
All of those fees, no, were not agreed to.
Okay, well, how much roughly was agreed to? I don't need you to get down to the exact penny amount, but what amount did you agree be paid to Woodburn and Wedge?
Probably about $70,000.
Okay, so are you asking the court then to invalidate or void the agreement that you reached in the mediation with Margaret Crowley?
The agreement was made based on a stipulation, so all of this was going to be settled and we were going to move forward. And Roger did not move forward. He had bad faith and this never went forward. So that was a compromise to try to settle all of this.
So did you ever file a document with the court to invalidate that agreement?
Your Honor, that's been asked and answered.
Hang on. I overrule the objection. Let me help in this way. The relief requested by Mr. Torvinen is specific to the numbers detailed and modified at the opening of this case. There is no, despite what Ms. Renwick said about she believes Roger should have to pay for all the attorney's fees ever incurred, there is no intent on my part as the jurist in this case to do that. There was specific relief requested in the original motion to retax or recharge costs. That relief does not include the fees we're talking about right now.
Okay, I understand where you're going, Your Honor. Thank you.
You're welcome.
May I proceed?
Yes.
Thank you. Ms. Renwick, how much of the $81,797.15 that Mr. Torvinen is still seeking is before October of 2017?
I don't know.
Did you seek a breakdown of that before we came to court today?
No.
Okay. Did you ever seek a breakdown from Mr. Torvinen as what fees would be normal and customary from 2017 versus any extra fees that were allegedly caused by Roger's actions or inactions?
I did not.
So do you have any evidence for us today as to what number this court should consider relative to the attorney's fees from the finding of vexatious litigant forward?
I do not.
Okay. Your Honor, I have no further questions for her at this time.
Thank you. Any follow-up questions, Mr.
Yep.
Torvinen?
Did you read the petition that we filed to surcharge?
I did.
Did you prepare it with me?
I did.
Did you come to an estimate about what a reasonable amount of fees for me to just administer these would have been?
Your Honor, I'm going to put Mr. Torvinen on notice with your permission that should this next question be answered by his client, I believe it is a violation of attorney-client privilege because he asked whether or not they prepared the petition together. As a courtesy, I'm going to let the court know and him know I intend to kick open that door if it's cracked.
Well, I guess.
No, Your Honor, may I respond to that? Ridiculous. That's ridiculous because it's verified. The petition's verified. It's nonsense.
Mr. Torvinen, if you go off on a rant again,
I apologize.
I will act accordingly. Please do not interrupt me or.
I'm
Mr.
sorry.
I will be the arbiter of whether and how privileges and doors to privileges are opened. The purpose of the question, as I understood it, was to follow up on the cross-examination of Mr. Evenson, asking Ms. Renwick about her understanding of the discrimination between fees that would normally have been incurred and fees that were, as it were, an additional amount, or if you will, caused by the malfeasance of Mr. Hillygus. For that reason, I overruled the objection. That means you can answer the question, Ms. Renwick.
And I apologize to the court, Your Honor.
Thank you. Ms. Renwick, do you remember the question?
No.
The question is, did you prepare with me an estimate of what the reasonable fees would have been year by year without all this litigation?
Yes.
You recall about how much that was? May I refresh the witness's recollection?
You may. I don't know of what use it is. It is detailed in the petition.
You remember preparing the schedule?
Yes.
And what is the number that we show on that schedule for what the fees reasonably should have been? Doesn't it say $10,500?
Yes. 10,500.
Do you still agree with what's asserted in the petition?
Yes.
No further questions.
Thank you. Mr. Spitzer, any questions, sir?
No, thank you, Your Honor.
Mr. Evenson?
Yes, Your Honor. Did you use any of your own independent knowledge or experience in determining what those reasonable fees would have been?
Yes.
Okay. And what independent knowledge and whatnot do you have on what the reasonable fees would be in a trust, guardianship, or administration case?
Well, just the experience I had paying all of the past attorney fees.
In other words, your only experience is from Mr. Torvinen, right?
I paid other attorney fees.
In this case.
Yes, when I was the temporary trustee.
I understand that. But Mr. Torvinen is indicating that you have indicated now that you independently came up with this number of $10,500 as being the reasonable, normal, usual number in a case of this size or extent. And I'm asking you what your basis is for that knowledge.
I don't know.
Okay, so is it safe to say that the number of $10,500 was supplied to you by Mr. Torvinen?
No, we discussed reasonable fees.
Okay. And where did that number of 10,000, whose lips did the number of $10,500 come from? Yours or Mr. Torvinen's?
Mr. Torvinen's.
Okay. Did you ever contact any other counsel, or did you ever review any other pleadings in any case or any other awards of attorney's fees to verify that that number spoken to you by Mr. Torvinen was accurate?
Well, I'm aware of all the hourly fees that were charged by all of the other attorneys when I paid all of the fees as the trustee. So I'm based on hourly fees and what it takes. That's knowledge I have.
Okay, so I guess moreover into mining this question, can you break down for me the $71,000 difference that is being sought in this case? In other words, Mr. Torvinen is seeking $81,000 to be surcharged against my client. You're indicating, and he's indicating, that $10,500 would be the reasonable number. Can you tell me why and what exactly about the $71,000 that you're seeking from my client is unreasonable?
Your Honor, I object. That's not what the petition says.
I overrule the objection. It's a legitimate question. In the end, you are going to seek damages, my word, not yours, from Mr. Hillygus as an offset against his share of the remaining estate, for example, or as a simple judgment against him or multiples of a number against him pursuant to 159. And I think Mr. Evenson is entitled to ask, what is the basis of your opinion, Ms. Renwick, that an excess amount, $70,000 in excess, represents unreasonable fees? I think that's a fair question. I'll let her answer it. Do you recall the question, Ms. Renwick?
Will you ask it one more time, please?
Mr. Evenson?
Thank you, Your Honor. Yes, Ms. Renwick, what fees are you asserting of the 71,000 odd dollars that you are seeking from my client are unreasonable?
I feel for all of the filings and for everything that we've had to do and for all of the hearings and for the amount of money that we have spent for all of the frivolous petitions and hearings, that it's excessive and it's due to Roger's behavior.
Okay, so can you point to any specific fees within the billing that you're referring to?
The majority of the fees that don't have to do with just the standard, just standard trust fees.
Okay, so I guess my question is,
I guess once a year, if everything was being paid for by the trustee, once a year there would be some fees to go to the court and to have everything approved. But there wouldn't be fees throughout the year. Those would be fees that would be paid to the trustee and the guardian. So any additional fees beyond going to the court once a year to be approved seem to me that would be unnecessary.
okay, now define necessary. Can you define what's necessary and what isn't?
Your Honor, I object to that question.
It is argumentative.
logical,
Hang on,
Okay.
hang on. Everyone else, please stop talking.
and it calls for a legal conclusion in this circumstance.
Mr. Torvinen, stop talking. I'm not going to warn you again.
I'm sorry.
The question was argumentative in the sense that it is more appropriate for argument. Mr. Evenson, your next question.
Thank you, Your Honor. You may recall that your attorney asked a question of Mr. Hillygus, my client, regarding the appeal that was filed at the Nevada Supreme Court that apparently did not contain any citations to authority. Did you understand and recall that question?
Yes.
Okay. Did you ever go over with any particularity the work that was done by Mr. Torvinen in response to that appeal?
Yes.
Okay. And did you ever break down the billing for that appeal?
No.
Okay. The net result that you're seeking today, as Judge Walker has indicated is that you, under the numbers that we see, are seeking to have Roger's share of the remaining corpus money in the trust given to you, right?
Yes.
Objection, again, she's already answered that.
I'm going to give
Right.
you some latitude. I overrule the objection. You can answer it, Ms. Renwick.
Yes,
And then you're seeking to have my client held personally liable for any overage on that pursuant to the guardianship statute that the judge cited.
yes,
Okay. And am I to understand that you're not doing that with any malice of any kind?
yes.
Are you aware? I'll withdraw the question. I have nothing further for her at this time, Your Honor.
All right, thank you. Mr. Torvinen, your next witness.
May I ask my client one more question I forgot to ask? With the
I'll give
permission of the
you
court.
latitude. Yes, you may reopen examination. Go ahead.
Thank you. Ms. Renwick, do you recall informing Judge Doherty, the court previously, that there was $25,000 of capital gain incurred by the trust unnecessarily? Do you remember that?
Yes,
And what was that based upon?
because the stocks had to be sold. So Roger sold the stocks so that he could pay off the house. So when the stocks were sold, it created a capital gains tax.
No further questions.
Any question as a result of that question, Mr. Spitzer?
No, thank you, Your Honor.
Thank you, Mr. Evenson.
Just briefly, Your Honor, on that question alone, was there a tax return filed by the estate or the trust?
Roger was the trustee at that time.
So again, was there a tax return filed by the estate or trust?
Your Honor, that is a misleading question. This is a self-settled grantor trust. It would have been an individual return. Trust that is misleading.
Mr. Evenson, is that your question?
Sure, whether or not any tax return was filed relative to the trust at all, sure.
Ms. Renwick?
I believe so, but I did not file a tax return.
Do you have a copy of it for the court today?
I do not.
Do you have any written documentation from any source that $25,000 in capital gains tax was actually paid by the estate relative to that?
I don't have that.
Okay, I have nothing further, Your Honor.
All right, thank you. Mr. Torvinen, your next witness, sir.
I rest, Your Honor.
Thank you. Mr. Spitzer, do you intend to offer any witnesses or examine any witnesses or offer any evidence?
No, Your Honor, I do not.
Thank you. Mr. Evenson, do you intend to offer any witnesses for examination or offer any evidence?
On the basis of what's been presented today, Your Honor, no.
All right, thank you. Mr. Torvinen, your closing thoughts, sir.
Well, Your Honor, I don't mean to beat up the record too much. And first of all, I apologize to you for losing my temper there. It's just been a long and arduous 8 years.
Well, Mr. Torvinen, inasmuch as you're offering an apology, I will cautiously accept it, but it is no small irony, Mr. Torvinen, that you are asking me to impose many thousands of dollars in costs, professional fees, and attorney's fees against somebody who lost his temper at multiple junctures in this litigation. I'm referring to Roger Hillygus. And as a professional, I must insist on better from you.
Well, Your Honor, I've appeared in front of you many times.
Stop there, Mr. Torvinen. You're on very thin ice. Please focus your thoughts now on your closing arguments, sir.
May I say one thing? I'm going to ask the court permission.
It's not relevant if it's in response to my comments now about losing your temper. No.
All right. Well, going back to the beginning, Your Honor, I'll just say this. This guy, Roger Hillygus, from day one, when he was removed in 2015, never recognized the power of the court to remove him, continued to insist, in fact, up through October 2020, that he was the trustee, and these are filed in with the court too, had the spurious, ridiculous guardianship papers issued by that outfit in Arizona, We the People, in the summer of 19, saying that he was still the guardian. And in the minutes, if I point you to the minutes, and actually in evidence, so, or part of the record, the minutes from December 22, 2015, where the court notes that Mr. Hillygus informs the court at that point that he does not believe that the court's orders apply to him, or words to that effect. They don't apply to me. I don't have to listen to you. Or I think it might have been exactly, I don't recognize the jurisdiction of the court. I think that's the quote when he was removed. And that was part of the basis to remove him, by the way. And that's in the minutes. But since that date, Your Honor, Mr. Hillygus has filed in January of 16, shortly after this, a motion to recuse Judge Doherty. That, of course, was denied. And then, let me bear with me. Let's see. A motion for a new trial. That was in, let's see, July of 16. And then also in July of 16, a motion to disqualify Francis Doherty. And then in August of 16, a motion to dismiss the cases with prejudice. I think that's the trust case for certain. I think the same thing was filed in the guardianship case. And then in August, also August of 16, a motion to disqualify me for conflict of interest, by the way. And then also in August of 16, a motion for emergency protection order of Susan Hillygus. By the way, this was after she was placed in Stone Valley. Under court order, I might add. And then, bear with me. I will get there. Okay. Then in, oh, nah, I'm not going to mention that. Waste the court's time. Oh, in 17, in April of 17, a renewed motion to demand the then chief judge of our jurisdiction, Patrick Flanagan, to permanently remove Judge Francis Doherty from presiding over the case. That might be it. Let's see. Oh, no. There's more. There's more. And then in October of 17, a motion to dismiss the guardianship case with prejudice. That's as to Susan Hillygus. And then this was in January of 18, a motion for redress of breach of trust against Casey Zusman. And that, by the way, indicated he wanted to remove her. And that would specifically and clearly trigger NRS 163.115 sub 4. Then he filed another in early 18, a motion for emergency protection of Susan. Again, she was in Stone Valley at that point. These were all denied, by the way. Then another in January of 18, another motion to dismiss, but this time the probate case for lack of subject matter jurisdiction. I might add that's just a reflection of his belief that the court had no jurisdiction over what he did in this case. And then in February of 18, a motion to deem me personally, Casey Zusman, Robin Renwick, vexatious litigants and for committing, quote, fraud upon the court. And that would have been also captioned as a method of removing, if I recall correctly, I didn't go back and read all these individually, but my recollection is the 2/2018, this motion was to remove Robin Renwick and Casey Zusman. So again, that triggers 163-115 sub 4. And then he filed, oh, never mind, I'm not going to mention that one. Then in May of 18, he filed another, quote, ex parte motion to recuse Judge Francis Doherty and to change venue. And then, oh, there's this, we didn't cover this, but it's in the record. He filed, I think it's 7 fugitive documents claiming he was trustee in 18 to try to besmirch the title to the Nob Hill residence. For instance, if memory serves me correctly, he filed a lis pendens, he filed a notice of trustee, he filed a lien. That's 3, and I think some of them were doubled up. But of course, that forced my clients to file a motion to expunge because he was trying to prevent the sale of property. Because of course, as we know from the record, because he said it was his property probably at least 5 times. I'm speaking specifically of Nob Hill. He thought it was his property. And of course, he didn't recognize the jurisdiction of the court. And of course, he's in his own mind was trustee and guardian. So what the heck? Besmirched the title to the property. And that took a few $1,000s anyway, when all was said and done, just that motion to expunge, let alone the Supreme Court actions. And I've listed in the petition briefly all of the things that were done here that cost all the money. And I also think it's clear to address Mr. Evenson's direct question, and I don't know exactly where it is, but somewhere in early 16, I clearly informed the court, that's Doherty, that I was now representing Ms. Renwick and at that time, Ms. Zusman in a fiduciary capacity, not in a beneficiary capacity. And I might add, if you look at the record, the fees that were paid generally, and I don't know if this is exactly the case, but generally all the fees that were paid in either December of 15 or January of 16, when Ms. Renwick finally took over as temporary trustee, were for my representation of her as beneficiary. That much I know is true. Mr. Hillygus answered most of his questions by asserting the Fifth Amendment against right of self-incrimination, and rightly so. That's what our Constitution says. But what he did say is, he said there was a Peterson Wealth Management account, and I think my client testified it was $350, and there was a house with equity of it somewhere in the same neighborhood. You add those together, you get about $700,000. Now we're at $163,000, Your Honor. And that shouldn't have been the case. And the reason it was the case is because of the conduct solely of Roger Hillygus. All of his actions are laid out in the petition we filed and in the record, which, by the way, when I did the Supreme Court brief, just one case, just the trust case, was 2,200 pages. I'm sure it's well more than that now. So when you talk about the guardianship statutes that you cited, talk about harming the protected person. Well, There's a bright line example of the harm that was done here. And it's all as a result of Roger Hillygus' refusal to recognize this court as having jurisdiction, having the ability to make court orders that affected the best interests of the protected persons, Jean and Susan Hillygus, and having the jurisdiction to enter orders regarding the trust. When, I might add, and this is crazy making to me, and I apologize again for losing my temper, his own lawyers, Your Honor, his own lawyers, July 2014, his lawyers, Woodburn Wedge at the time, said, hey, Judge Steinheimer, okay if you take jurisdiction of this trust? Yeah. And so that's what happened. At that point, the guardianship was going, I think, at least for Jean. And the court took jurisdiction by stipulation at the behest of his lawyers. And so if you want crazy making, think about this. None of the titles I mentioned when I went through the docket sheet specifically mentioned this. I think maybe one did, but at any rate, be that as it may, if you look back at Roger Hillygus' pleadings, they argue repeatedly, either one, the court had no jurisdiction over the trust, or two, as a family court, which is what Judge Doherty was, there was no jurisdiction over the trust, despite, and I can't remember the name of the case in Nevada Supreme Court 10 years ago, holding that a family court is a general jurisdiction court and has jurisdiction, particularly in a case like that, where they were administered concurrently by court order. So he was arguing repeatedly that there was no jurisdiction. And frankly, if you think back about it, that is the motivator. If you look through the weeds, or as my father would say, look at the forest through the trees. If you look at the forest through the trees and all of those pleadings he filed to dump the previous jurist, that's what he was doing. That's what he was saying. No jurisdiction from the beginning. Now, why is this important? Well, I know what 163.115 sub 4 says. But I think you can also award attorney's fees under that statute for the overall conduct, not just the specific surcharge actions. And frankly, Mr. Evenson was right when he cited those cases, and he did read them, as did I, the California cases. Those were done because the beneficiary misbehaved in one particular case or another. I've never seen, and nor could I find any case, and I looked long and hard, where somebody behaved in a manner as Mr. Hillygus did over the course of multiple years in bad faith at every turn, from not filing inventories to leaving out assets to missing assets to filing an inventory with no beginning balance, no ending balance. You couldn't tie into anything. Yeah, I didn't mention that. The stuff that he filed was absolute nonsense. I'm speaking the accountings. I'm a CPA. I couldn't make heads or tails out of it. None of it. It was so frustrating. And I'm probably echoing my frustration here now. And I apologize to the court again. Nothing he filed. Oh, by the way, he tried to do this. The second accounting that he was ordered to file, I don't know if you saw this, Your Honor, he tried to file it under a security cover that would not give access to anybody else. So I wouldn't get a chance to look at it. So my client wouldn't get a chance to look at it. But I can just tell you, that action alone is bad faith. And I think in the totality of things, because the way he conducted himself throughout this case, throughout the case, I think that you can reasonably think that he was really, he did not recognize he was removed as trustee or guardian. Trustee specifically under 163.115. He failed to recognize the jurisdiction of the court to do that repeatedly. and acted accordingly. So although he did file 2 specific motions to remove my client and Ms. Zusman as fiduciaries or petitions, he acted as if they were not in that role in the first place from the beginning. And I assert to you that, and I heard what you said about the 159, 345, and 346 and 347. And I've read the statutes themselves, and I believe they are applicable. But I think you can also apply 163, 115 sub 4 under the theory that I gave you. It comes within that statute, because what are we really saying? We're saying that he's trying to remove, and he was effectively by doing the same by not recognizing the trustee and the guardian in a bad faith manner, not in a good faith manner. And I think you can read the statute that way. I agree. 159, 346, and 347 specifically grant this court the power to impose fees beyond just the trust rates, which would be normally his half under the trust document. And I exhort the court to do that because his conduct caused the substantial diminution of this trust and the estates of the parties. We're down to $163,000 from what was probably $750. It should have never happened. So that's financial harm. And without going into too much detail here, I will tell you this. The statute also talks about physical harm, if I recall correctly. And after accusing, outrageous, can you imagine you're the son or daughter of a parent and your own sibling accuses you of murdering the parent? Who does that? But this is in the record. It is in the record that he picked up his mother from Stone Valley on or about August 8, 2019 without color of law. It's in the record. It's also in the record that she died shortly thereafter. She was brought back here, well, of course, after he holed up in the apartment in Los Angeles and he had to call a SWAT team. But that being said, she died shortly thereafter, within about 2 months, because she died on October 16, 2019. And I submit to you that you could reasonably infer that he shortened her life just because of the conduct. So there's physical harm to Susan Hillygus, let alone, and this came up repeatedly in Judge Doherty's court. And ultimately, Susan, if I recall correctly, Susan Hillygus was excused because it was so agitating to her to see her children at battle on multiple occasions in front of the court. The judge excused her. She suffered from Alzheimer's. She didn't understand what was happening. And you know, there's another example of the physical damage that Mr. Hillygus's choices caused in this case. I think the record is also clear that my client only filed what was necessary to deal with Mr. Hillygus and the wacky things that he said. Yes, wacky. Most of them were not legal. Most of them were nonsensical. Most of them were difficult to decipher. She filed the minimum that she had to do because she was always aware that it was necessary to keep the costs down. And I pointed this out to you, and I'm just going to say this in the petition that we filed. My fees are now left $82,800, or $81,800, excuse me, or thereabouts. That's over well, let's think about it. Really, in a fiduciary role, that is since in or around December 22, 2015. So what are we? 5 years plus, right? Past that date. Roger Hillygus incurred and paid more than, including the $21,000 that he never got permission of the court to pay by the trust. With wood burn wedge, in a span of a little better than 14 months, he burnt up $101,000. Try that on. It's just amazing. And it's amazing to me as counsel for this lady and for the other fiduciary that there would be complaint about my fees at this point in light of the more than, has to be more than 2,200 pages, sheer speculation. There's probably 26 or 2,700 pages in that, in the record now in the trust case. I might add this, and you can add this to your plate if you want some more tools, because there are so many things that Roger did. I, as a lawyer, was challenged immensely to keep track of everything, and I lived it. I can't imagine the difficulty of Mr. Evenson. My heart goes out to him. He's a friend of mine, and he's a good lawyer. But that being said, I remembered about the capital gain. It's in the record. Judge Doherty found it as a fact that Mr. Hillygus caused $25,000 of capital gain that wasn't necessary and could have been spread over many years at much less cost because he liquidated the Peterson Wealth Management Fund in the autumn of 2015 to pay off the mortgage, by the way, which he did without court approval after the court took jurisdiction. It was a surprise to Judge Doherty, let me tell you. So, I think he could be surcharged with that too. So add that to the list. So I suppose we should have filed a 4th supplement, but as I thought about the case last night, I thought, you know what? That should be surcharged too. Because frankly, that was a breach of trust that damaged Sue and Jean Hillygus to the tune of $25,000. You should be surcharged for it. Your Honor, I'll loop back to 159, 346, and 347 again. I appreciate you bringing those up. I believe that the court, because, and you mentioned this, but I agree, and I looked at this last night, does have the jurisdiction to take jurisdiction over the trust because the guardianship still exists for purposes of windup, and that's what the statute says. And that's exactly what we're doing here. And so I believe that you do have jurisdiction to do this. I might add, Mr. Evenson mentioned in his opening that Klabaka is an unsighted case, and I have fast case up, and it doesn't say anything about that. So I don't know if I'm incorrect. I'll certainly fall on my sword, but it does not say it's an unpublished opinion. So that being said, Your Honor, I would like you to bring this to an end after these so many years. Frustration, hair pulling, pure puzzlement over what happened here. And I'll just point this out for the court because it's part of the court record. You might want to read it. Ryan Earl did a GAL report that was entered into the record sometime in 15. I think it was mid 15, maybe late 15. But in that report, he talked to all the parties. He talked to Roger, talked to Robin, talked to some of the healthcare professionals. And this is right before we went to mediation. So that would have been, I think it's in the summer of 15, because the parties went to mediation sometime in the early autumn of 15 with Margaret Crowley, who, by the way, did a very good job. But what it says is, that this is Ryan speaking, I am concerned. And the reason I'm concerned is because Roger cannot put himself in the shoes of anybody else. He only sees his own perspective from what he wants to achieve. And so therefore, Judge Doherty, because he was speaking to Judge Doherty, I'm concerned about how this thing is ever going to work. I invite the court to go back to read it. I'm paraphrasing out of my memory, but it does say that. Boy, oh boy, did that guy look like a fortune teller. He was spot on, because that Roger, his conduct from the beginning had little to do with the other beneficiary, and really had little to do with his parents, because after all, why in God's name would you, unless you were completely self-focused and not looking out at anybody else's perspective, why would you show up to Stone Valley in August of 2019 and take your mom out of a facility where she'd been staying for 3+ years? It's mind-boggling. A person that was not all self-focused, as I think Ryan was saying in so many words, and without empathy, by the way, I might add. Ryan doesn't say without empathy in his report, but I think if you read between, if you look at the forest of the trees, that's what he's really saying. Why would somebody do that? Why? Unless they were motivated that way. And you know what? This thought just came to my head just this very second. You know, you can draw a straight line between what Ryan Earl said in mid-2015, and Roger's conduct in taking his mom out of Stone Valley in August of 19. He was a fortune teller, and I've never known Ryan Earl to be a fortune teller. He's a good lawyer, though. So, Your Honor, one more thing. I mean, you're sitting this, at least in the trust case, as a court of equity. And I think, even though that we put that estimate of there of what it would have taken, you know, $10,500 to administer this thing by just going yearly to do an annual report, an account and a report about the guardian. You do this, you sit in that seat day in and day out. You know what the costs are if something's just a regular administration. You know what the costs are if something's just a regular accounting. You see it day in and day out. You could probably take notice of it, what a reasonable fee is and what it should have been. So I don't think that's a weakness. It's an estimate. But the court has well more experience than this lawyer does about what's reasonable. You make those decisions every single day, I would think, at any rate. So, in conclusion, Your Honor, the record speaks for itself. The process speaks for itself. Mr. Hillygus' conduct speaks for itself. And the language from the California cases is clear, although again, I'll loop back to what Mr. Evenson said, he's correct. They're by action, not action, but event by event. But there's never been a case like this, in my recollection, where you had this conduct that was conducted every single day, all the time. And Judge Doherty was patient with him. In fact, in the Supreme Court case, I said, I think the words were that she had the patience of Job with Mr. Hillygus, was so deferential to his rights, granted him multiple continuances, denied 2 motions to have him deemed a vexatious litigant before she finally approved the 3rd one, because she was so concerned about protecting his rights and about giving him a voice and having his thoughts and his concerns be voiced to the court, so the court was fully informed. She bent over backwards, the patient to Job. Unfortunately, the words of Ryan Earl come loop back in here. He does not, never will, apparently, well, that's speculation, have any concern about the viewpoints of others, about the feelings of others. It's only him. And that's what drove this from the beginning. I think the record's clear about that, and drove all of this nonsensical litigation. So I ask that you surcharge them, however you think the best way to get there. I agree with the guardianship approach. I think there's a trust approach, and clearly, at least to the res, that is the trust balance. There is a way to do it under the California common law. And I might add, if you want to look at NRS 163.115 sub 5, it specifically says the remedies above do not preclude the court from other remedies under common law or statute. So it's written in an expansive fashion. And therefore, I think you can apply the statute that way. And I clearly think you can apply the California common law in addition to the guardianship statutes. And then I just gave you another $25,000 I think he should be whacked for, because it's in the record as a finding of fact for the capital gains. He should have personal liability up above the res asserted against him by way of judgment. Thank you, Your Honor.
I make a finding that paternity has been established.
He was a potential future to his children.
We're here for the court's order to show cause.
Okay, so that takes care of one motion.
Maybe somebody could tell me what the status is.
Any preliminary issues we need to take care of?
You want to make sure that she's put on house arrest? As you know, the Supreme Court has
Mr. Spitzer.
Thank you, Your Honor. I'd like to begin by remembering Susan Hillygus a bit. She was a lovely lady that I had the pleasure of representing since sometime in 2016. She was always very pleasant and of perhaps interest in this matter. In those occasions when I spoke to her about her children, she did not have any ill will toward either one of them. In fact, was supportive of both of them. Not in any specific sense in terms of what they had done involved in this case, but just in general, her gratitude, her motherly love for both remained up until the last time I saw her, at least. Your Honor, in regards to the matters before the court today, NRS Chapter 159 covers misdeeds by guardians in the statutes that you've cited. 159.345 deals with property in which a guardian is guilty of gross impropriety. 159.346 deals with any violation of a protected person's right. This court has an ample record before it. It has prior findings of facts and conclusions in regards to Roger Hillygus's conduct during the time he was guardian, which march up until December of 2015. Prior to that, though, Your Honor, the statutes also contemplate sanctions in regards to individuals who adversely affect the property of a protected person. And those are in 159, 305, and 315. I would suggest to the court that there is, in the overall statutory scheme of Chapter 159, ample protection for those whose actions affect adversely either the property or the protected person's rights. With that, Your Honor, I'd submit this matter.
Thank you, Mr. Spitzer. Mr. Evenson?
Your Honor, thank you. And I am certainly still learning a great deal about this case, listening to Mr. Spitzer and Mr. Torvinen bring up proceedings and facts that I've been unable to research in the short amount of time I've been on this case. I'm always amused when lawyers and case law talks about reasonable. I've said for a couple of decades that a lawyer's definition of reasonableness is doing what that lawyer wants you to do. Because if you don't do what that lawyer wants you to do, you're being unreasonable. And so whenever you start talking about fees and the boundaries of what's reasonable and what isn't reasonable, a lot of times that's a matter of perception. And certainly the perception of Mr. Torvinen and his clients are very clear. That my client has been, well, I mean, he called him that guy. I mean, this guy, and talks about how he doesn't care about anybody but himself, and all these very personal and terms that are more suitable for argument when making a case on the people's court than you are in front of this court. And this is not a court of emotion. This is not a court to judge my client's character or Ms. Renwick's character or anybody else. This is a court of law and facts. And to some extent, I know that I'm in a difficult position here coming in as an outsider, but in another way, I think that that's a true benefit to my client. I think it is important for cases like this that are complicated and deep and involved to occasionally have a new set of eyes come in from a different perspective. I thought it was very, and I don't want to say humorous in the sense of funny, I would say it humorous in the sense of dark lawyer humor that we would have if we were all having a beer together, that Mr. Torvinen says, what sort of sibling accuses another sibling of killing their parents? I think I hear that once or twice a week. I mean, I think I hear it in the vernacular of they're just spiteful towards each other, or there's just an issue with how one of them views caring for each other and those kind of things. That is not when it is made in a meaningful manner along the lines of a criminal investigation, that's one thing. But for one sibling to accuse another sibling or a family member to accuse another family member of causing the death of a sibling, it can be related to stress, it can be related to travel, it can be related to arguments, it can be related to a number of things. To use those types of phrases and sayings made in the course of an 8-year case to say to you, Your Honor, that his client is now entitled to receive all the money, I think it cheapens his argument overall. And I think it cheapens what this court intended to do with regards to the findings it intends to make in this case. I think that this court is aggravated, and I don't mean that in a bad way. I think courts are human beings and they can be aggravated about the proceedings and about what's gone on and about what lawyers are doing and clients are doing and all of them are doing. And it's certainly very clear many things from this case, even on this early on as I am in it. Obviously, I don't bill enough because I'm not named Woodburn and Wedge. I don't know how you accumulate a $115,000 bill in 14 months for this kind of a case. I don't think I could sleep at night if I billed somebody that kind of money for 14 months of involvement in this kind of a case. I think it's a crying shame that neither my client or Ms. Renwick or somebody at some point in the course of the settlement with Ms. Crowley or something, didn't say, how is any of this reasonable to this point? But to blame it all on my client who sought legal counsel and then was billed by that legal counsel for work that was done 7 and 8 years ago, and to now come back and say, well, that's a reason to make sure he gets nothing and there's this surcharge and everything else, that finding should have been made years ago. That argument should have been made years ago. The moment that Ms. Renwick agreed to those findings with Margaret Crowley is the moment that that door needed to close and never be opened again. But instead, it's used like a club on the proverbial harp seal of my client to continue to make a point that he's some bad guy who doesn't care about people. I don't think it supports that finding at all. I think it supports a finding that perhaps he was taken advantage of by one of the premier law firms in Reno. Those findings could be made just as easily and maybe should have been made 7 or 8 years ago. I'm certainly not suggesting that, but I'm saying that those things could in fact be out there and need to be viewed at this time. And Judge, because you're a court of law and because you're a court of facts and you take that role as seriously as you are expected to, I think it is important that we go through the statutes that are being discussed today. It says at NRS 159.345 and NRS 159.346, if a guardian at 346, subsection 1, if a guardian, and then subsection 2, if any action by a guardian is deemed to be. If I'm hearing everything correctly today, my client wasn't a guardian on this case since 2015. Did I misunderstand that or did I get that date wrong? So what are we doing today about stuff that happened in prior to 2015 when he was removed? Are we all of a sudden saying that he should have been held accountable by the court at that time, that that's what should have happened and he needs to be brought before the body of the court in order to do that? And then, of course, you have the minor little fact that he was removed in 2015 and neither one of these statutes existed until 2017. So at the time he actually was guardian, the statutes under which you're now trying to hold him responsible for paying all these fees didn't even exist. There might be an argument there that this is an ex post facto taking of property under the US Constitution and under those kind of things. Of course, it's not a criminal matter, but it does go to the point that if he wasn't the guardian when this stuff went on in 2015 and 2017, and that statute didn't come into place, how can this court hold him to be responsible for that? That is perhaps why initially Mr. Torvinen did not include that argument in his petition to surcharge. And while certainly he's going to take the court's guidance when it's offered to look at that statute as being a way of doing things, that statutory language is not inspecific. And it is very specific as to what it says and what it does. And so then what you get to is, well, he wasn't the guardian and that statute may not apply, but you know, he cost us all these attorney's fees and he did all of these things under the trust. Well, again, going back to the NRSs that I cited to in my opening, but to be clear for the purposes of the record on this closing, when you look at those particular statutes under the guardianship, there are even limitations as to what can be done to somebody if they find themselves running afoul of those statutes. If you look at the plain language of those statutes, it again indicates under 159.345, if a guardian, which he wasn't, is guilty of gross impropriety in handling the property, makes a substantial misstatement or fails to file an account or does any of those things, the court may impose a penalty in the amount of $5,000, not to exceed $5,000, and order restitution of any money misappropriated from the estate, which must be paid to the estate of the protected person. It does not talk about ordering attorney's fees. It does not talk about a surcharge. It does not talk about anything like that. It says when they're a guardian, these are the options. Then you go to 346, again, for a guardian. Twice the actual damages incurred. This under subsection 2. Well, let's back up a second. Let's go to subsection 1. If a guardian violates rights, a court may take an appropriate action. So that says if a guardian does X, the court may do Y, okay, which is take any appropriate action. Fine. Under subsection 2, if any action taken by a guardian is deemed to be deliberately harmful or fraudulent or to have been committed with malice, the court may also impose twice the actual damages incurred by the protected person and attorney's fees and costs. This does not say that a beneficiary of a trust or that somebody who acts in a outside the judicial capacity manner, if they do something, then this court has jurisdiction over them. Why? Because the court only has jurisdiction over guardians and protected persons. It doesn't have jurisdiction over people who are not clothed with letters of guardianship. They can be involved in the case. They can come to court and assert their arguments, but they are not covered by this statute. And Your Honor, I appreciate your...
I'm so sorry for interrupting. I apologize. I want to give you an opportunity to respond to this because it's your argument has appropriately piqued my interest, Mr. Evenson. And so I would ask, of what moment, if any, is it that your client purported to act under color of law, claiming that he continued to be the guardian when, for example, he removed his mother from Stone Valley? In other words, the documents about which I've taken judicial notice, in those documents, you don't have to agree with this, and your silence, your client invoked his right, and I recognize your silence is not assent to it. But in the documents that I took judicial notice of during Mr. Torvinen's examination, your client purports to identify himself as the continuing guardian over his mother and the continuing trustee over her trust. And so of what moment is it, what legal moment is it, if any, that he acted, my words, under that color of authority?
Your Honor, I think in the context of the guardianship statutes, if I may, and I know, and where I was going when you interrupted me, which is fine, but where I was going is that this state took great action in 2017 to fix the guardianship statutes. And there were a lot of problems wrong with them. And we can go into the Nye County Public Guardian and all the other issues that took place with all of those various circuses around the state. And in addressing an entire statutory rework, some things sometimes get left out. Now, if it wasn't contemplated by the legislature that you could have somebody act as my client has been accused of acting, and you are correct, I'm not saying he did anything wrong, and I'm not waiving any arguments or making anything I think legally that can be used against him. But in response to your question, it does not appear as if the statutes considered taking property and money from somebody who's acting under the color of law that you prescribe. Now, we can agree, because he's invoked, he is being criminally prosecuted for the actions of which you have alleged, in that, obviously for the kidnapping and obviously for the allegation that he presented these documents. That appears to be the sole statutory remedy that is available. If the statute had wanted to encompass doing X, Y, and Z and then penalizing X, Y, and Z for having those false kind of things, they could have done that. Of course, I do not believe that that is a further limitation to the civil remedies that could be obtained by the guardianship or the trust on their own in a private action. But of course, we are at a point in this case where attorney's fees are begetting attorney's fees. And at some point, as you accurately mentioned, the bleeding needed to stop. Of course, everybody can sit here and say, well, that would have been great in 2015. I mean, that would have been fantastic, but that's not where we ended up. And so I don't think that the legislature in their rewrite contemplated the specific facts that we are speaking of here. And I certainly agree with the court, as you mentioned earlier, that we have the ability to maintain the guardianship. I mean, sadly, Sue passed away in October of 2019. And so, but simply put, my client has not been guardian for a longer period than the statute of limitation exists to go after him civilly for any of those things that took place. I mean, I think the bottom line is that there's just nothing in the statute that allows the guardianship statutes of 159, 345, and 346 to be used against Mr. Hillygus. And Judge, I'm happy to answer or answer any other questions or anything you have in regard to that argument.
Thank you. No, I don't have any other questions. Thank you, Mr. Evenson.
Okay. Additionally, Your Honor, as I move on to the trust statutes and Mr. Torvinen citing the NRS 163.115, that deals with the removals. And it says, if the court determines, under subsection 4 of that statute, if the court determines that a proceeding instituted pursuant to subsection 1 by a settlor, co-trustee, or beneficiary of the trust against a trustee was not instituted in good faith based upon probable cause, the court may order that the settlor, co-trustee, or beneficiary who is maintaining the proceeding against a trustee pay all or part of the cost of the proceeding, including without limitations, reasonable attorney's fees. It is interesting to note, Judge, that this statute was not invoked at the time that these incidences were going on, and specific requests were not made of Judge Doherty pursuant to that statute to find my client liable at the time. And what I find—
Hang on. I have to interrupt in this way. I apologize, Mr. Evenson.
You bet.
I recognize you're a newcomer to this case, but that's actually not true. What I mean by that is in the April 20th, 2016 order, Judge Doherty issued a $15,000 judgment against your client and indicated that there was an ability to surcharge that amount against him when the distribution from the trust was ultimately made. So
I'm not disagreeing with that, Judge. I completely understand what you're saying there. I get that. And I'm not arguing that that shouldn't have been done. But what I'm arguing is that that eliminates anything prior to that date. That $15,000 is in the record. It may not have been paid or covered, but that is, if you want to argue it, the law of the case, res judicata, collateral estoppel, maybe another Latin term or two I can throw out. But that to me is the end of that issue up to that date. And as you indicated, you were looking at things after the vexatious litigant finding, which was in 2018 and is referenced within there. So, and here's, and I'll go into this, Judge, as I think, me going through the statutes and talking about them, I made those arguments a couple times, and I don't want to be that guy that goes over the same thing over and over and over again, although I'm perfectly capable of that. But, when you look at 163, that was done in 16, but it was not done in 17 and 18 and 19 on any of these things. And the problem that I have with that is simply, Judge, is that when you listen to Mr. Torvinen go through his laundry list of motions and things that weren't done, and he's certainly entitled to that. It's certainly an effective argument to be made when you're seeking the kind of money that we're talking about today. But the problem is that you indicated that was in August of 16 that the attorney's fees were granted. Well, that seemed to cover a great deal of what Mr. Torvinen was talking about. Then you talk, excuse me. Then it was discussed that Judge Doherty made the finding of vexation litigant, I believe in September of 18. So where is the specific breakdown of fees? And in relevance to any of the statutes that you're using or anything else, Mr. Torvinen goes to great lengths to argue that this guy is a bad guy and has no feelings and no emotions and everything else. But what he didn't do, and what evidence wasn't presented today, is as a result of this motion filed on this date, the fees were this much for me to answer for this pleading. On this motion on this date, that was obviously unnecessary. This much was expended. This amount, this action caused this specific financial harm to the ward, and this should be paid for. That's what I found so amazing about the $25,000 issue. While it may be a finding of fact from Judge Doherty that the $25,000 in extra taxes was done, I've never seen a tax return or evidence it was paid. So even though it's a finding of fact in the order without a receipt or without somebody having filed a tax return for the trust, I hate to say it this way, but it's no blood, no foul. There's not, okay. In theory, he cost him an extra $25,000, but no tax return has ever been done. So nobody's ever paid that. Is there going to be an end tax return done? We don't have any of that information. So now you're being asked by Mr. Torvinen to award $25,000 of the most speculative damages you can see, which those that aren't proven. And then he uses that to kind of bolster the case for, well, all of my attorney's fees. And keep in mind, Judge, the surcharge that is being asked for is not for a specific case. It's not for a specific issue. You are being told that there's $89,000 in attorney's fees and that the regular price is $10,500. First of all, what evidence is there that the regular price is $10,500? Mr. Torvinen put it in a pleading. Mr. Torvinen told his client, she agreed with it under oath. Normally, you would expect another well-regarded trust attorney in Reno to come in and testify. I reviewed the records. I reviewed this in this case. This would, given the facts and circumstances, X would have been a reasonable amount here. This amount is above X. That amount should be taxed or surcharged to Mr. Hillygus. That was not done in this case. And that goes again towards the argument I made in my first few sentences about this not being a court of feeling, but a court of law. If you're being asked to surcharge my client out of the entire amount that he is supposed to be taking, and moreover, that entire amount being given to his sister, then you should at least have a specific item in the record that you can turn to say, this thing, this pleading, this action was taken, it cost this much to fight, this lawyer testified that this was unreasonable and unnatural and inexpensive, and this amount should be it. What you have is the classic shotgun approach of, I spent all this time on attorney's fees, it should have been 10,000, I'm at 81, give me the $71,000 and give it all to my client, make sure he doesn't get anything. That's the sum total of Mr. Torvinen's argument today and the evidence that was presented today. I mean, he had every opportunity to go through each billing in his billing that was attached to this court and make a record about what that proceeding was about, why it was unnecessary, what went on, all that didn't need to be done and everything else. Instead, he's having my client testify about matters that are clearly established in the record already. That's his choice. But I think that goes to the weakness of the position of this case and the weakness in trying to say, I have this excessively high amount of attorney's fees. I'm wanting paid for it. I'm not going to go through and specifically say what each item was for and how it was relevant or not relevant or anything else. I'm just going to say, give it all to me and make sure you take it from my client. And oh, by the way, give it all to my client. I don't think that that's the intention of the statutory scheme here. Given the facts that are in the record and giving the facts that are in the record, I am not going to argue that this court is being unreasonable in looking at sanctioning my client further than Judge Doherty did in 2016. I'm not going to come in here and tell you that. I am going to come in here and tell you that the case that has been presented by Mr. Torvinen is so lacking factually and legally that the statutes do not comport with what's going on, and that the trust statutes as well don't comport with what's going on, that there is literally, I'm going out on that limb here, but I'm going to say I do not see a statutory way for this court to make the order that Mr. Torvinen is asking for based upon the statutes and based upon the complete, total, and utter lack of evidence presented today on the specific issues of these $80,000 plus in attorney's fees being excessive on every single count. It is literally, this is what I've charged over the course of 8 years. Give it to me out of Mr. Evenson's client's share, and then give all the money to my client. That's not a legal argument. That's not how things are done. You come to court and you say, with your chin out, I did this work. This is what I did it for. This is why it was wrong. And we never heard that today from anybody. We get a lot of references to the record. We get a lot of references to Roger perhaps not being the best guy in their opinion. And we get a lot of vitriol from his sister, but we get no proof to the level necessary for this court to issue the ruling that they asked for. And on that basis, Judge, today we're asking that you do not surcharge Mr. Hillygus any money other than the $15,000 that was originally ordered by Judge Doherty back in 2016. Thank you.
Thank you. Mr. Torvinen.
Well, I specifically, and I'm not going to concede anything, but clearly up and above the court orders that Judge Doherty awarded attorney's fees would have been the fees incurred after Mr. Hillygus was designated a vexatious litigant. That went back to 2017. So that would cover some of those other fees because that's one of the remedies in the statute. And then, Your Honor, again, I'll say this. Well, it's my client just said it's not fair. And after all, what is fairness but a court of equity? And in a trust matter, unless as I pointed out in our brief, unless the legislature specifically clipped the court, this court sits with regard to those trust assets as a court of equity. This court, as a court of equity, can grant my client the remedy requested. There is, not in Nevada, but there is substantial common law in California on this issue. So you have the authority to go that direction too. And that's what I tried to point out to you. Probably didn't do it very articulately in my closing. And I would add, I don't think it's a too far stretch. It's not a bridge too far to find that this conduct, that course of conduct, and I read all the pleadings into the record here in closing, and they're in the record anyway. It's not a stretch for this court to find that Mr. Hillygus, on multiple occasions, the ones I mentioned and others, I didn't mention all the pleadings he filed, came within the purview of NRS 163.115 sub 4, because after all, he was not recognizing the trustee. He was operating, as you pointed out, under color of law, as if he was the trustee and the guardian. And, you know, as Mr. Evenson pointed out, you know, the statutes are written, some say it's like making sausage. But when that statute was adopted, and I think sub 4 was adopted in 2017. When sub 4 was adopted, who in their right mind?
Are you talking about 163.115 sub 4?
Yeah, sub 4. Yeah. When it was adopted, I think it was in 17, I think.
Well, there were amendments in 17 and 19. If I look to the 17 amendment, just so that we can be clear, the 17 amendment only added to subsection 4. What is now subsection 4 had been previously a different number. So it in fact, the 17 amendment didn't change subsection 4.
Yeah, it was in a different place, right? Okay, well, I stand corrected. So, but my point is this, and this goes to Mr. Evenson's point about, you know, when statutes are written and legislatures meet and committees consider bills, who in their right mind would have considered this kind of conduct instead of properly filing a motion to dismiss the trustee? And he did file two in 16 and 17. He acted as if he was the trustee and the guardian under color of law. And I suggest to you clearly, and that's been from the beginning. So Mr. Evenson may fault me about being not detailed enough, and I certainly will supplement the record if the court deems it necessary. But that being said, this guy acted as if he was the guardian and the trustee from the day he left office, or actually was booted by Judge Doherty, acted under color of law. And I think that under these circumstances, that triggers 163.115 sub 4. Thank you, Your Honor.
You're welcome.
Your Honor, can I ask for one clarification?
Sure.
I have the vexatious litigant, and I'm only going because I don't have the 6 bankers boxes of files in front of me, but I'm going from Mr. Torvinen's motion on page 6. It says that that my client was deemed a vexatious litigant on a September 7th, 2018 order by virtue of a May 8th, 2018 hearing. I've heard 16, I've heard 17. Is the September of 18 order the sole vexatious litigant order, or were there others? And I just need that to be clear for the record.
There were the order that resulted on September 7th, 2018 was a result of a third motion for declaration of your client as vexatious litigant. 2 prior motions had been denied. This order was the third of those motions to declare him a vexatious litigant, and it was ultimately granted. So there are no other orders declaring Mr. Hillygus a vexatious litigant other than September 7th, 2018.
Your Honor, may I be heard?
Sure.
I think, and you mentioned this, and I didn't go back and read that 45-page order. Well, I read it a few weeks ago, but I think there is, and you mentioned this, and I don't know, and I have it in front of me, and this may answer Mr. Evenson question about Judge Doherty having that relate back to sometime in 17.
Well, the 18 order specifies that you are directed and allowed. So it says at paragraph 3, Mr. Torvinen is directed to submit the expenditure of fees associated with responding to Mr. Hillygus, both in responsive pleadings, investigation, and appearance at all hearings in which these vexatious pleadings were filed and addressed by the court from January 10, 2017 through March 1, 2018.
Okay. Your Honor, may I make a remark for the good of the order?
Well, we're off-roading a bit. I'll give you some latitude. You're interrupting Mr. Evenson, who I'm going to let make whatever record he wanted. Go ahead, Mr. Torvinen.
Well, I just want to apologize to you, Your Honor. I've appeared in front of you many, many, many times, and I've never done that before. And I don't know what to say. I'm just sorry.
Here's perhaps the best response I can give. You know, we have the benefit, we the attorneys, of all knowing each other well. I would say you all have the misfortune of knowing me a couple of decades, but irrespective, to quote Judge Hardy, in court, which we are in, I have no friends and no enemies. And Mr. Torvinen, this is going to sting, but I suspect Judge Torvinen would have sanctioned Todd Torvinen if you had undertaken that behavior in front of him.
I understand.
And so I'm just going to leave it at that. Mr. Evenson, is there anything else you wanted to say, sir?
No, Your Honor, I just wanted that clarity before we close the record today as to when the vexatious litigant finding was, because a couple of dates had been bandied about. I just wanted it to be clear. Thank you.
Indeed. So let me offer a comment in this way. Mr. Evenson, I'm glad you came in. Your participation today has been helpful to me. You were right when you said that perhaps the advantage you had was being the new guy in the room, because you got to take sort of the 100,000-foot view. And focusing me in particular on the language in 159345 and 159346, I suggest to you is going to be remarkably helpful to your client and useful to me. I am not prepared to issue a final ruling from the bench because I need some additional information. Mr. Torvinen, you must supplement the record with a more specific analysis pursuant to NRS 159.344, addressing the factors related to a determination of attorney's fees. You'll recognize, Mr. Torvinen, at subparagraph 5, there's a laundry list of factors that should be considered, whether the services conferred any actual benefit, the qualities of the attorney, et cetera. Those are the Brunzell factors, the Miller-Wilfong-Brunzell factors. And so you must supplement the record with that. You must also supplement the record to tease out which fees you seek reimbursement for and pursuant to which order. Because Mr. Evenson's argument is exactly right. There is no question that in an April 2016 order, Judge Doherty adjudicated $15,000 in fees. It would appear to me that some of those fees are also included in your plenary request to surcharge fees back. If I'm in error, you can point that out to me.
Yeah, they're backed out, Your Honor. They're separate.
All right, if they are, fair enough. It also appears there is jurisdiction to assert fees, as Judge Doherty's vexatious litigant order indicates, for a period of time between January of 17 and March of 18. It would appear as well that fees can be assessed pursuant to NRS 159.0486 because at paragraph 2, if a court finds a person as a vexatious litigant pursuant to subsection 1, the court may impose sanctions on the petitioner in an amount sufficient to reimburse the estate of the protected person. And so I believe we have jurisdiction and notice to Mr. Hillygus for fees certainly through April of 2018. What becomes more problematic is this. Mr. Hillygus, as a result of an agreement, what was to be a global settlement agreement between the parties, was confirmed as successor trustee and guardian of Susan Hillygus on October 14th, 2015. And let me pause for a moment to offer a comment. I have a remarkably privileged job, which I'm deeply and profoundly gratified to occupy. I'm the temporary occupant for hopefully the indefinite future of Department 7 as a district court judge. And I always tell people one of the great privileges of my job is I see the issues that arise in people's lives from before they're born, across the entire course of their life until after they die. And unfortunately, I never met Susan Hillygus or her husband, Gene Hillygus, and I'm deeply and profoundly saddened I never did. I'm sure I would have enjoyed them as human beings and people. The aside I simply want to take is this. The loss that the Hillygus family felt from the death of a beloved father and then the death of a beloved mother is palpable still to this day. I never met either of those decedents. Unfortunately, I'm sure had I met them, I would have enjoyed them. They have intelligent, capable children. I'm sure that's not by accident in terms of who Mr. Gene and Miss Susan Hillygus were. How human beings react to loss never ceases to surprise me. I do not know why Roger Hillygus did what he did in these cases. What I do know is that a mere 2 months after what was to be a global agreement resolving issues between he and his sister, among others, there was an emergency hearing and Judge Doherty had to remove Mr. Hillygus as guardian and trustee on an emergency basis, following his own testimony that he used the bulk of the liquid estate from the trust to pay the mortgage on the protected person's residence where he and his wife were living rent-free. In fact, Roger also at that time withdrew a $15,000 cashier's check, money from the trust, to pay for his own representation through Carlin Kidder at the Barber Law Group and/or Keith Tierney. As a consequence of those malfeasances, and as a consequence of the liquidation of cash and the use of that cash to pay the mortgage, Judge Doherty noted that an additional $25,000 in unnecessary capital gains were accrued, which destroyed the cash position of the trust and negatively affected the status of Susan Hillygus. By April 20th of 2016, Judge Doherty found a specific breach of trust against Mr. Hillygus and permanently removed him as trustee and guardian. Ms. Renwick and Fiduciary Services were appointed as successor guardians and Fiduciary Services as the successor trustee. A $15,000 judgment was entered against Roger Hillygus. I note that $15,000 could not at that time be subject to doubling pursuant to NRS 159.346, because 159.346 did not exist on April 10th, 2016. And so I could not magnify those damages pursuant to NRS 159346 in an ex post facto fashion, as Mr. Evenson adroitly and correctly pointed out. By June of 2016, an order entered by Judge Doherty approving the sale of the former family residence, Ms. Susan and Mr. Gene Hillygus' home, and authorized the placement of Susan Hillygus in Stone Valley, still allowing Mr. Hillygus, Mr. Roger Hillygus, and his wife to stay in the former home as tenants at will until the sale consummated of the home. That resulted, unfortunately, in Roger's obstruction of the sale of the home, the resulting call out of law enforcement, including a SWAT team, to confirm that Roger had actually vacated the home after unlawful detainer was alleged. The residence was successfully sold, but subject to a $15,000 5-year holdback because of the behavior of Mr. Roger Hillygus. In February of 2017, the trustee settled with Roger Hillygus' wife, Debbie, unfortunately now, as I understand it, his ex-wife, but nonetheless, she was paid her share of monies and caregiving fees, for the care that she had provided to Susan Hillygus. So notwithstanding that Mr. Roger Hillygus engaged in a series of defalcations, perhaps fueled by his broken heart over his father's death, perhaps fueled by the decline in his mother's life, I have no idea why he chose the behavior he chose. But notwithstanding that, Judge Doherty segregated and paid money to his wife for care she had provided to Susan Hillygus, even though Ms. Debbie Hillygus and Mr. Roger Hillygus were living rent-free in Susan Hillygus' home. By September of 2018, in a very detailed order, which I incorporate by this reference, Mr. Hillygus was deemed a vexatious litigant, and Judge Doherty noted with her well-known eloquence a variety of observations about Mr. Hillygus' conduct. Specifically, she noted that Mr. Hillygus fails to recognize the waste his obstructionism has caused his mother's estate. Such waste has created insecurity for his mother as she relies solely on her assets to fund her costs of care. Yet because of Mr. Hillygus' incessant and frivolous pleadings that have not enhanced the protected person's quality of life, Mr. Hillygus has virtually single-handedly diminished the protected person's financial condition. The substantial depletion of the trust and estate affects the ability of the family and co-guardians to maintain the protected person's lifestyle in the manner to which she has become accustomed and to which she is entitled. Mr. Hillygus has used his time and the expenses of the estate to stall, obfuscate, and create a circus out of these proceedings. That is stinging, pointed, perhaps the strongest language I've ever read, authored by my friend and colleague, Judge Francis Doherty. After being declared a vexatious litigant, a mere 11 months later, with no legal authority to do so, acting on fraudulent, cooked up, specious documents, Mr. Hillygus kidnapped, that's a term of description, not term of art, his mother from Stone Valley on August 8, 2019. A mere 2 months later, she died. This record does not reveal adequate evidence from which I can conclude that her death was hastened by her son. The actions of her son, I should say. But I dare say that Miss Hillygus had to be aware on some level, notwithstanding whatever confusion she was suffering, that a SWAT team was summoned to her former residence in 2016. And she was present in 2019 when a SWAT team was summoned to rescue her from the barricade created by her husband. How that stress could not have affected her life begs any reasonable explanation. Mr. Hillygus has never provided a final accounting from 2006, when he was ordered by Judge Doherty to account for his actions as the previous guardian. That accounting remains outstanding and unaccounted for. I mean that in every sense. I impose a penalty of $5,000 pursuant to 159.345 against Mr. Hillygus as a penalty for misappropriation of the protected person's estate as detailed in the orders discussing his breach of trust, and because the accounting remains outstanding to this day. It is apparent that Mr. Hillygus, by his actions, created havoc in this case. It is no excuse for Mr. Torvinen's lack of decorum, however. I expect Mr. Torvinen and any professional involved in this case to maintain their decorum, notwithstanding the out of control, probably criminal, and certainly inappropriate actions of Mr. Hillygus at many turns in this case. I am disgusted as a jurist by what Mr. Hillygus chose in his mother's life. It is apparent that his choices had negative effects on Susan Hillygus and on the entire Hillygus family and everyone around this case. It is unquestionably true that in a commonsensical way, but for Mr. Hillygus's malfeasances, which were many, expenses would not have been as high as they are in this case. However, and I reiterate my thanks to Mr. Evenson, NRS 159.345 did not exist until 2017. And by its express terms, NRS 159.345 and 346 begin with the phrase, if a guardian, 3 critical words. I cannot and will not impose sanctions against Mr. Hillygus as a guardian for any actions he undertook after he was removed as guardian. It is an open question in my mind if I could sanction him for actions under color of law. Among the many tangled webs Mr. Hillygus has woven in this case is the interesting observation that while he defends his action in again, term of description, not term of art, kidnapping his mother by saying, look, I have a jury verdict from We the People in Arizona confirming that Judge Doherty had no jurisdiction to do all the things she's done, none of which have been set aside by the Nevada Supreme Court, on the one hand, and on the other hand say, oh, but I wasn't guardian, and so you can't sanction me, Judge. That is unfair, improper, but it also may be true. I must reflect further on it. However, as Mr. Torvinen points out, Mr. Hillygus remains a beneficiary of the trust. That status has never changed. In addition, he has been trustee, but he remains to this day a beneficiary of the trust. And pursuant to NRS 163.115, subsection 4, if the court determines that a proceeding instituted pursuant to subsection 1, by a settlor, co-trustee, or beneficiary of the trust against a trustee was not initiated in good faith and based on probable cause, the court may order that the settlor, co-trustee, or beneficiary who is maintaining the proceeding against a trustee pay all or part of the costs of the proceeding, including, without limitation, reasonable attorney's fees. The provisions of this section do not preclude any other remedy available. That is the broadest possible language. And so for all of those reasons, I intend to craft an order supplied with facts to be provided through Mr. Torvinen's supplement, which my words surcharge or retax against Mr. Hillygus all of the attorney's fees that were caused by his malfeasance. I find and note specifically for the record that the estimate of attorney's fees that might otherwise have occurred in this case of $10,500 by Mr. Torvinen is accurate, reflective of the reasonable rates charged in both trust and guardianship cases in this jurisdiction, and completely consistent with my experience awarding those fees in thousands of cases over the last 13 years. Mr. Torvinen, do you have any questions about what you need to do to supplement the record, sir?
No, I do not, but I would point out some legal authority for the court. Because the court asked me to address the vexatious litigant statute that's exists under 159-0486.
Yes.
And I think I also briefed the judge on this when the third motion or one of the motions, that when a court takes jurisdiction under 164-010 by, and I did point this out in the petition, that the statutes of the will statutes are adopted by reference, and those are between items 139 and 156 or something like that. And I point that out because the court did take jurisdiction, and that makes, let's see, I have the statute up here if I can read it. Bear with me one moment. It's 155.165 applicable. And that is the vexatious litigant statute in the will section, which is adopted by the trust statutes and incorporated when a court takes jurisdiction. That's all I want to point out to the court. And so if it's okay with the court, I would also address that statute at the same time as I addressed.
Here's how we're going to handle this.
Okay.
You must supplement the record in the ways I've described.
Okay.
If you believe there is additional legal precedent which applies, you may include points and authorities to the supplement.
Okay.
Mr. Evenson will have 10 days after you provide the supplement and any additional argument you seek for the court to consider to file a responsive pleading if he believes that is necessary. I'm not ordering you to do that, Mr. Evenson, but if you would like to respond, you certainly can. Mr. Spitzer can weigh in at that time, meaning at the time of any responsive pleading or the time due for any responsive pleading by Mr. Evenson, if Mr. Spitzer has a position. And then, of course, you can reply 5 days later, Mr. Torvinen.
Okay.
I will issue my order in writing, resolving this matter consistent with my comments this morning after that supplement and those pleadings have been perfected.
Your Honor, would you do me a favor and put a gun to my head? When do you want the initial pleading due?
It's 10 days from today, Mr. Torvinen.
Okay.
So I look at a calendar. Today is the 26th. 10 days is, by my calculation, February 5th, Friday. Mr. Evenson would then have until Monday, February 15th, and you would, because I gave you 5 days and there's a weekend, have until Monday, February 22nd for your reply, Mr. Torvinen.
What did you say, February 22nd? Is that what I heard you say?
Yes.
Your Honor, I believe the 15th is President's Day, just to be clear.
If it is, thank you for pointing it out, Mr. Evenson, and that if the 15th is President's Day, and I think you're right about that, then obviously it is President's Day. His opposition, or I'm sorry, your opposition would be due on the 16th.
Thank you, Your Honor. Your Honor, for the purpose of the record, I have to state my objection to allowing Mr. Torvinen to supplement the record. I think the court was quite clear last time that there were not going to be any continuances granted. I had not made a motion to continue, but I had inquired of Mr. Torvinen, who pointed me to that language. And we were prepared to deal with what we were dealt today. I appreciate the extra time to deal with these other issues, but we do object for the purpose of the record to granting Mr. Torvinen time to supplement the record.
I understand that objection and respect it. I overrule it. It is common for judges to seek supplemental briefing or supplementation of the record before final decision. And so for that reason, I overrule it. So ladies and gentlemen, I mean sincerely the comments I now offer. I have a privileged position which I'm deeply gratified to occupy, and it has been my privilege to touch on issues within the Hillygus family as I have in this case. My deepest and sincerest hope is, no matter what the final details of my written order may be, that Miss Hillygus, I'm sorry, that Mr. Hillygus and that his sister, Miss Hillygus, I'm sorry, Miss Renwick, I apologize, are able now to apply their considerable labor, talents, and efforts to grieving and to forgiving. I wish you all good day. I hope you all remain happy and you remain healthy and happy, and your extended families are healthy and happy. Counsel, thank you for your time.
Thank you, Your Honor.